Well, we're happy to say that we have, the first step is we publish our rules and regulations of the board. They're published in English, Spanish, and Korean. So we do make the rules available. Additionally, the licensees, some licensees are very fortunate to be represented by groups such as CAGRO, which in fact provides translation services at board hearings in addition to city council meetings, which I believe. There is, at the liquor board, we understand that there are many neighborhoods in this city and there are many backgrounds of people who are licensees. So we're trying to be accommodative and sensitive to their needs.
Okay. Additionally, you spoke about the main or a major concern, which is the misuse of BD7 licenses. You said that you intended to move on correcting this problem. Could you speak more to how you intend to correct this very long-standing problem? And is this an administrative change, or would there need to be further state legislation?
Well, at this point, I believe we are, the board, in consultation with MOLBA, KGRO, and other groups, has a plan. Our executive secretary, Samuel Daniels, has engineered the plan, whereby we will allow a short period of time for certain licensees to come into compliance, after which time aggressive enforcement will commence. There is no secret that for years, Rule 5.03 violations, that is a liquor board violation for failing to act as a real tavern, were simply, licensees weren't written up. You can go back 10 years, 5 years, and look at inspection reports where other violations were cited, but a warning was issued that you're not operating as a tavern. Since, Madam President, you've been involved in the Park Heights situation, since Councilwoman Middleton and the community groups have really come to life. This movement has since, I would say, October. Our inspectors have been aggressively writing up establishments for violation of Rule 5.03. We have fined, I believe, 6 different establishments in that time for a violation. In all of those 6 cases, since November 1st, there has been, they were all first-time offenders. And so there's only so much that a board can often do on a first offense for a violation of that nature. I can tell you, though, that those, with the policy that Mr. Daniels and the board have worked on, we are not dismissing any cases from the past. We're simply allowing the licensees to know exactly what we expect and exactly what Rule 5.03 means to us, and that is that you actually have to be a tavern. You cannot be a fake tavern that's operating as a liquor store.
What is the time frame for the remedy?
Less than 60 days.
From?
Today.
Thank you. Mr. Chair, can I continue with questions, or am I limited?
Yeah, no,
I can continue.
Go right ahead.
What is the current fine? What's the current fine for selling alcohol to minors? And do you feel that that fine is an effective deterrent?
I am very excited. I have some evidence that literally came in from our most recent sting operation. Let me first address your question. The maximum fine under law that can be fined on a first offense is $500. It is the policy of this board to fine the maximum fine in every case possible. That is an inflexible policy, but it demonstrates this board's, the gravity that this board takes with respect to underage drinking. Now, it gets more interesting when you move into multiple violations. On a second or subsequent offense, the fine can be as high as $3,000. And in fact, this board, on a second offense, routinely average fine is over $2,000 on a second offense.
And this isn't a statewide policy. This is a choice of the board.
The state or no, this is actually limited by statute.
No, you're saying you give the maximum. I'm saying in Baltimore County, are they doing the same thing? You're saying that your board has made a decision to, on the first violation, sale to minors, go with the maximum fine?
That's correct. That's just a policy of this board. The
Your
state
board,
law is
okay.
$500 maximum.
Okay. And your choice is the maximum?
That's correct, on a first offense. I think it's important that we let licensees know just how serious we are about this problem. I also want to let you know that on a subsequent violation, this board has suspended at least a dozen locations, have closed them down temporarily for underage drinking violations. And a case last month, the Sugar Hill Tavern, the license was revoked as a result of violations that occurred there, including the 3rd, 4th, and 5th underage drinking violation, 3 of them in 1 month with 3 different employees. So their license was revoked, and it was their 3rd, 4th, and 5th.
Thank you. My next question is about intimidation, and then I'll have one more question, and then I don't know if anyone else has any. What type of evidentiary standards does a board need to have when dealing with community intimidation to prevent community members from filing protests on a liquor license? And once you learn of the intimidation, what steps are taken?
Well, intimidation is obviously it's a factor that's hard to define from time to time because of the nature of the silence. In a specific case, recently, there is an allegation that witness intimidation existed in a matter, and that the residents could not procure 10 immediate vicinity neighbor signatures as a result of said intimidation. The board, on its own initiative, therefore, decided to accept that matter based on those allegations. There are many forms of intimidation. Sometimes it's as simple as a bar owner asking what residents are doing. Sometimes it's as simple or as obvious as placing a sign up in front of your bar saying that these are bad neighbors, why are they bothering us? But sometimes the intimidation is far more nefarious and more dangerous. And in a case where we feel that there's been a representation made by a community group that there are real underlying threats to signing your name on a petition, well, then this board, without even looking at the merits of the case, will certainly allow for a hearing on that license. And that's exactly what we've done. So
I guess the real question would be, like, getting to what do you do as far as, like, for example, if, a community member filed numerous complaints, a community member along with the community, in general, filed numerous complaints about an establishment, and the establishment sued the community member for, you say defamation or interference with business because the community member was trying to get the board to enforce the violations. I mean, that seems to me like a significant form of intimidation.